All right, so I'm here with Mike Bennett, who runs an estate planning firm called Helios Integrated Planning. Mike is one of the estate planners we work very closely with, and I'm bringing him on today because we've had more conversations about mortality planning in the last 2 months than we've had in the past 2 years. Naturally, I thought it would be good to bring Mike on and have him shed some light on trusts and estates. So, Mike, it's good to have you here.
Oh, thank you. Thank you for having me, Tushar. I appreciate it.
So Mike, as you know, I help clients with all aspects of their financial planning. So I'm always recommending to my clients that they need to set up their trust and do their will, especially if they own property or have children. So what exactly is a trust and why do I need it?
A trust is basically a contract. It's nothing more than that. But what a trust allows you to do is exert control over spaces in your life that you ordinarily wouldn't have control. Things like who's going to get your assets, how do they get those assets, who's going to make financial decisions if you can't make them for yourself, who's going to make healthcare decisions if you can't make them for yourself, and who'd be the guardian of any minor children. So if I could boil down, why you need it down to one word, it's control.
Okay, that's helpful. The other thing that we all think about is why can't I just write a will? I've heard that I can just write something on a piece of paper and put it in my bedside drawer, and that'll hold up.
You absolutely can. It's a lot of people in my position aren't going to tell you that you can do things like that. You can, but it's buyer beware. There's a lot of different issues that go into that. But in California in particular, in order to have a legal will, it just has to be signed, dated, and written by you. So yeah, you could do that. But chances are you're not going to have the experience to capture things like guardians and who's going to make healthcare decisions for you and a bunch of other things. So there's a good chance that you'll miss some things.
Okay, that makes sense. What about probate? That's a word that I hear thrown around a lot. What exactly is probate? Why do I need to care about it?
Probate's brutal. If probate is just a legal transfer of assets when somebody dies. It's a court supervised process. In California, it can be just absurdly expensive. Attorney's fees and executor fees are all based on the gross value of the estate. So just by way of example, a $500,000 estate would trigger $13,000 in attorney's fees, $13,000 in executor fees, and about $3,000 to $4,000 in court costs. So you're looking at about $30,000 coming right off the top. There's 3 categories of assets that are exempt from probate. There's assets that are held jointly, assets with a beneficiary designation, and assets held in trust. And so that's one of the major reasons why people do trusts in California, is to avoid probate.
Okay. How long does that court process typically take?
Yeah, that's another downside of probate. If it goes perfectly, it lasts 7 months. And I can tell you from experience, it very rarely goes perfectly. On average, 9 to 12 months. But it can be a lot longer, especially in this day and age, because a lot of courts are limiting the number of court appearances that can be made. So you may not even get a hearing for several months now at this point to even start the probate process.
Got it. Yeah, that's a long time to get to your assets. The other thing that I run into often with our clients, especially in the Silicon Valley, is that they have maybe illiquid stock options because they're working at a private company or a venture capital fund or private equity fund. How does the courts typically deal with those types of assets?
Yeah, and that goes to the third reason why people don't like probate. There's the cost, there's the time, and the privacy aspect is the third one. Particularly in a venture capital type scenario, any illiquid or non-cash assets are valued by the court, and so now they have a court-appointed appraiser that has to value those assets. Well, if you're like a lot of venture capital firms and other Silicon Valley type places, that's pretty private knowledge. And you don't want a bunch of people knowing those types of things. Well, guess what? That's now public record, that inventory and appraisal of those probatable assets. And so that could be not catastrophic, but pretty terrible result for a lot of people.
Yeah, okay. That makes sense. As we shift from probate to kind of thinking about, families, people with children, many of our clients who have children who are minors. So how do parents typically think about their successor trustees? And is that something that you see people change over time? And furthermore, is there a right age to really pass your money down to your kids?
That's I'm going to give an annoying answer, but I promise I'll expand on it. My annoying answer is always it depends. What I like to tell people is that you know your kids better than you or I ever will, and so you're going to know what's right. But rest assured, you can make it right. The types of trust that we're doing, for your clients are revocable trusts, and so I like to say they're set in sand and not set in stone. And so I like to use my own kids as an example. I've got a 10-year-old daughter and a 7-year-old son, and right now they get payments for healthcare, education support, but they don't get to control things until they reach certain ages. And right now, my wife and I have it listed as 1/3 at 25, 1/3 at 30, and 1/3 at 35. I joke when those kids are teenagers, we're going to change it to 55, 65, and never when they get to control things. And then hopefully when they're in college and they're getting older, we'll start to think of them as our successor trustees, and we'll be able to take off those restrictions. But it's not, and so that's my long way of saying it depends. Every kid's going to grow up a little bit differently. Every kid's going to have different aptitudes when it comes to managing money. And so but just, I guess what I'd like to stress is, and the takeaway would be, just know that you can change that as your life changes.
Yeah, I like that phrase, set in sand versus set in stone, because I do come across some clients who say, oh, I need to get this, perfectly right the first time around. And in reality, it sounds like people make several amendments to their trust over their lifetime.
Yeah, I mean, my wife and I initially did ours in 2008, and then we've amended it in 2013 and 2018. It just happened to be every 5 years. I don't want to sit there and say that it has to be every 5 years. What I like to say is whenever you or a beneficiary have a significant change in health or wealth, that's a good time to look at it. But it's, there's no perfect answer on that.
Okay. And what do you recommend to people who maybe don't have like a close friend or family member who can act as their trustee? What's the route that they should consider?
So we see a lot of corporate trustees, and in California, private professional fiduciaries, where those people's only role is to serve as trustees. One of the reasons people like them is it's a disinterested third party who's going to be able just to look at the terms of your trust and just go with it. Now, granted, they'd work with somebody like you, though, who knows the family. And so that's the major benefit to having like a private fiduciary or one of these independent trust companies. They're able to do those types of things and keep you in the loop. And you're going to have more background than anybody else. So we do see those professional trustees in play if you don't have a family member who's capable of doing it, or who frankly you don't want, they can't handle their own finances. So they sure as heck you don't want them handling yours.
Okay, yeah, that makes sense. Well, so let's talk about that. So in your experience, what's the typical cost for like a corporate trustee? And actually, we didn't talk about this yet. What's the typical cost for an estate plan?
Yeah, for an estate plan, it can range. We're a document preparation service, so we're on the lower end. But we see a trust-based estate plan, which includes all the documents you would possibly need. We generally see it run anywhere between $2,500 and $7,000. It really just depends on the geographic area that you're in. It's such a wide range, and there's a lot more that goes into it than people realize. But it's still, it's still something that does not need to be that difficult to do.
Okay, got it. And do you have an idea of pricing around like corporate trustees and what they typically charge?
Yeah, generally it's a percentage of assets under management. And so it usually starts at somewhere between 1.25% and 1.5% of assets under management for like the first $1 million, and then it goes down from there. But it's every place is a little bit different. Private fiduciaries generally charge an hourly rate with an annual minimum. And usually that hourly rate is somewhere between 75 and 125 bucks an hour. But it's, they definitely, those are some sticker shock, probably some sticker shock there for a lot of people. But in certain scenarios, it can actually save money. And I don't work for any of these places, so I don't want to make it sound like a sales pitch for them, but there's definitely the right circumstances where they're, where it's a good fit for your family.
Yeah, we actually have that offering now. We have a private trust company with our broker dealer that offers these services, and I haven't yet put a client on that platform since most seem to have a friend or family member that they trust to do that. But I can imagine a scenario where there's an elder 70-year-old woman or something who doesn't have kids, or maybe doesn't have a spouse who might need some guidance. So
well, yeah, and I can tell you that I have used LPL's trust company and been very impressed with how they've handled themselves and how they don't just try to rack up fees. They get things done. And so it's been a good experience for me.
Okay, great. That's good to hear. What about people who have multiple marriages or children with multiple partners? How do they typically think about their beneficiaries and structuring trusts? And I'm sure this is one of those answers where it depends, but like, what are some guidelines that you'd suggest?
Yeah, so it is definitely an it depends answer. Every family is going to be a little bit different. I see, I worked with one last week where the main intent for the client was to try to take care of their spouse first, but they wanted to make sure that the surviving spouse couldn't change the beneficiaries on everything. And so we see a lot of that. And so, for instance, this couple, they each had 2 kids from their previous marriage, but they owned a home together. And so they left a right of occupancy in the home for the surviving spouse. And so they could make sure that the spouse had a roof over their head, wasn't going to get kicked out, and those types of things. But then the other thing they did is they purchased a life insurance policy where each spouse purchased a life insurance policy that paid directly to their kids. And so at the first death, you didn't have one of those scenarios where the kids of the deceased spouse were waiting for the proverbial evil stepmother or stepfather to die before they get anything. And so it was a good way to grease the wheels on that, and something that just made it a lot more palatable for everybody involved. Okay.
Yeah, that makes sense. I'm sure you've had some sticky conversations with some people over the years.
I'm a pleasure to have at cocktail parties for those types of reasons.
Yeah. Okay, cool. Another issue that might arise is estate taxes, and that seems like the exemption changes every 5-ish years or so. But what's the current exemption, and what are some common ways individuals can reduce their estate tax liability?
Yeah, so the current exemption is $11.58 million per person, which is quite a bit to shelter. If you're up around that number, good for you. There's not many of you at this point. Ways to reduce estate tax liability can be done through lifetime giving. There's also giving to charities. So you can take, even if you were worth more than those numbers, if you're giving a portion of your estate to charity, that comes off the top. Additionally, one of the things I try to stress to people is there's 3 things to know about you to do the perfect estate plan. We need to know when you're going to die, what are your assets going to be when you die, and what are the tax laws going to be in the year that you die. So we're batting 0 for 3 every time, no matter what. And and you probably run into that stuff with financial planning as well. In order to do the perfect financial plan, there's these unknowns that are you're just never going to know them until the time comes.
Oh, absolutely. Especially in, times like today where you're seeing rampant layoffs and even talented people are losing jobs. It's very difficult to come up with the perfect plan, but sounds like it's just a process.
Yeah, and we just rest assured that we do have the flexibility in place where it's going to be perfect for today that takes into account reasonable changes in the future, similar to the financial plans that are put together. So I don't want to make it sound like we have no idea what we're doing.
Yeah, absolutely. You mentioned life insurance policies. I guess tell me a little bit more about that. So are life insurance policies subject to estate taxes, and what do you recommend to clients about beneficiaries on insurance policies?
So if you own the life insurance policies, they would be subject to estate taxes, but again, only over and above that 11.58 million. Now, there are ways to get those insurance policies outside of your taxable estate for estate tax purposes, through different irrevocable life insurance trust planning and those types of things. It's not as common these days since the exemption amounts are so high. But I'm a huge proponent of life insurance, and I don't sell it. I think a lot of people are completely underinsured. For me in particular, again, having a 10-year-old and a 7-year-old, that's the biggest asset of my estate. And so my wife and I, we've named the trust as our beneficiary because we want it flowing along with our trust. If something happened to my wife and I, and we just named our kids as the beneficiary, they would just get all that money when they turned 18. Well, I don't want my kids to be millionaires when they turn 18. That's, I think, just a recipe for disaster. So by naming the trustee can still use the money for them, but again, they don't get it. They get 1/3 at 25, 1/3 at 30, and 1/3 at 35. So making sure that your beneficiary designations are in line with what your estate plan says is a big miss that I think a lot of people just don't realize that it's great that you have documents, but make sure you got everything working together on it.
Okay, got it. And so do you recommend, like, I guess in your scenario, with the life insurance beneficiary, is your wife the primary and then it goes down to the trust, or how do you guys think about that?
I've just done the trust as a primary because my wife is the beneficiary. We're each other's beneficiary on the trust. And so I did have one scenario about, 13, 14 years ago, where by naming a spouse first and then the trust, it didn't work out. There was a joint car accident where one died immediately and one died a couple months later. Well, that person who died a couple months later never took custody of that money. And so basically we had to probate one of the life insurance policies. So I like naming the trust as primary beneficiary when it comes to life insurance, because it just covers all contingencies. And no matter what you do with your trust, you'll never have to update your life insurance beneficiary designation again.
Got it. Okay. And what about, I guess, real estate? What tax considerations should I have if I inherit my parents' real estate in the future?
Wow. There's a couple things to consider there. One is from the income tax perspective. Assuming that their names were the only names on it, you would get what's called a step-up in basis for income tax purposes. And so what that means is if you were to go to sell it the very next day, you would have zero capital gains. And so you wouldn't have to pay any tax on it. And so that can be a huge thing. To only be responsible for capital gains from the date of death through date of sale is huge. On the other hand, I hear a lot of people say, oh, well, I'm just going to stick my kid's name on the house. Well, that's not good, because you lose out on that full step up in basis for income tax purposes. So that's a fairly significant thing. There's another tax issue that comes up quite frequently, and that's property taxes. In California, if generally speaking, when a property transfers, the county wants to reassess that property for property tax purposes. There's a big exclusion to that when it comes to transfers between parents and children. And so if it's the parent's principal residence, or up to $1 million in assessed value on a non-principal residence, you as the child, you can retain their property tax number, which in some cases can be huge. Yeah. I mean, we had one last year that I saw. It was a property in Los Gatos that had been owned by the family since the 1960s. Well, parents died, and they got to keep the parents' property tax figure, which is huge in a scenario like that.
Yeah, absolutely. Wow, that's super helpful. Last question I have for you, Mike, is, we're having this conversation in May of 2020. COVID-19 is prevalent. That's had me and several of our friends, family, clients, obviously thinking about estate planning and more specifically their healthcare directive. What considerations should people have as they put their healthcare directive together, and are there any specific wishes they should outline? What's your guidance there?
Yeah, I think anybody over the age of 18 should have at least an advanced healthcare directive. It's too easy to get. You can get them at your doctor's offices. I mean, you can get them online. And again, you're not going to hear somebody like me say that to too many people. But if you're doing a full estate plan, the healthcare directive should be part of it. As far as considerations go, this is my father-in-law loves this example. So I often say that I don't have my mother listed because she'd never be able to let me go. I also don't have my father-in-law listed because he'd be way too willing to see me go. Sometimes I say he'd be willing to put a pillow over my head, but that's probably a little inappropriate to say. But no, it's so you want someone who can make that difficult emotional decision at a very difficult and very emotional time. And even if they want something different for you, they're going to have the courage to do what you want for you. And so that's probably the much more appropriate way to phrase that.
Got it. Cool. Well, Mike, that's all the questions I have for you. Do you have anything else you'd like to share with our clients?
No, I mean, I guess one little thing is estate planning has never been easier to do. And so get it done. It doesn't matter how you get it done, just get it done. And so, yeah, thank you for inviting me, and I appreciate your time as well.
Absolutely. Thanks, Mike.